Hello, I'm Mark Wellborn.
And I'm Chris Smith.
Today we'll be looking at EC Regulation 261 of 2004, which is a regulation which deals with assistance and compensation to passengers in the event of denied boarding, cancellation or long delay of passengers. We'll be looking at the regulation article by article. We'll then be going through significant case law. We'll be looking in detail at the extraordinary circumstances defence, then looking at evidential issues and going forward proposals for change. Regulation 261 of 2004 originated as a proposal by the European Commission to amend and update EC Regulation 295 of 1991. That regulation dealt specifically with minimum levels of compensation to be offered to passengers in the event of denied boarding due to oversales. That is where an air carrier had sold more seats on a flight than were available and more passengers had shown up to check in for that flight than there were seats available to carry them on the aircraft. The regulation extended the ambit of the previous regulation by going into areas of denied boarding not related to oversales and providing for compensation to passengers in the event of denied boarding, cancellation, and also providing for assistance in the event of long delay.
Like all EU regulations, the regulation itself is divided up into a preamble and the articles themselves. The preamble provides background information on the purpose of the regulation, and it's the articles themselves which provide the provisions and limitations afforded to passengers. When one considers that, like any EU regulation, it must be interpreted purposefully, it's important to have a good understanding as to the purpose or the intention of the regulation itself. We'll be looking at this in further detail later, but for reference now, we'll be focusing on recitals 14 and 15 of the regulation. The regulation itself is directly enforceable, that is, passengers themselves can rely upon the provisions without the need for any secondary legislation to implement the regulation itself. In the UK, however, there is secondary legislation, but this is solely for the purposes of setting out criminal sanctions for those carriers which breach the provisions set out in the regulation itself.
Looking at the articles of the regulation itself, that is the operative provisions of the regulation, Articles 1 and 2 set out the intention of the regulation, the purpose of the regulation, and also define certain terms that are used within the regulation. Unfortunately, extraordinary circumstances is not defined, is not a defined term within the regulation, and this is an area that has caused some difficulty in actual implementation. Article 3 defines the scope of the regulation. It applies to commuter carriers, that is, air carriers with operating licenses issued by EU community nation states, and it applies to those carriers whether operating within, to, or from EU member states. It also applies to non-commuter carriers, but only when they are operating from the EU. That is, if a non-commuter carrier is operating a flight from outside the EU into the EU, then the provisions of the regulation do not apply. The regulation applies to travellers travelling on a commercial fare. It does not apply to those passengers travelling on reduced rate fares that are not available to the public. However, it does apply to those passengers travelling on frequent flyer benefits. The passengers must present themselves for check-in at the time stipulated by the carrier. If no time is stipulated, then they must present themselves for check-in at least 45 minutes prior to departure of the flight. If the passenger does not do so, then they do not obtain the benefits of the regulation. The regulation only applies to air transport in fixed-wing aircraft. For those passengers who are travelling from a third country into the EU, the regulation does not apply if the passenger has been provided with assistance and benefits in that third country. There is no requirement for a minimum standard of assistance and benefits in that third country. Article 4 deals with denied boarding. Whereas the previous regulation was specifically directed at passengers who are denied boarding due to oversales, Article 4 in the regulation is much more expansive. it relates to all passengers who are denied boarding for whatever reason, unless they've been denied boarding for reasonable reason, i.e. Health grounds, security grounds, or inadequate travel documentation. Passengers denied boarding against their will be compensated by the operating air carrier. In addition, they will be entitled to assistance, which Chris will look at in detail later. Article 5 is concerned with cancellation. Article 5 provides that where a flight is cancelled, passengers will be provided with assistance and, subject to certain conditions, compensation. Cancellation means the non-operation of a flight that was previously planned and on which at least one place was reserved. If a flight operates, even albeit several days after it was originally scheduled to operate, it has not been cancelled, merely delayed. Article 6 of the regulation is concerned with delay. The regulation provides that in the event of long delay, which differs dependent upon the sector length, the passengers will be offered assistance and reimbursement where appropriate. The regulation itself does not provide for any compensation in the event of long delay, but that has obviously been subject to a decision in the European Court of Justice which has changed that framework. The regulation itself prescribes certain distances for specific lengths of delay for which assistance must be provided, following which assistance must be provided by the carrier. In the case of flights from 0 to 1,500 kilometres, that delay length is 2 hours. In the case of flights from 1,500 to 3,500 kilometres, or all flights within the community, that delay length is 3 hours. For flights in excess of 3,500 kilometres, the delay length is 4 hours. And again, that delay length relates to the provision of assistance by the carrier. The regulation itself, again, does not provide for any compensation for delay. That, again, was an issue dealt with by the ECJ in the Sturgeon decision.
Having looked at the core provisions of the regulation, that is the causes of action, we're now going to take a brief look at the remedies that are available arising out of each cause of action that Mark has just spoken about. You'll see from the diagram on the relevant slide that there are common themes, common remedies that permeate each cause of action, those being compensation, rerouting or refund, or certain welfare rights that are afforded to passengers. At the top of the diagram, you will see cancellation. The compensation that's available for passengers whose flights have been cancelled depends on the sector length, that is, the length of the flight affected. Mark has already taken you through those parameters which apply, but as a recap, there are